Good morning. Are you Brandon Bonton?
Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I received that report. I'm going to take judicial notice of the court file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the state.
At this time, then, I am going to find that Mr. Bonton is not competent to
Can I
stand trial. Hang on, let me say what I need to first, and then I'll let you.
Illuminati, man. I got the government microphone chip in my left knee, my right ain't hollow. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testify and take a lot of tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation 2-year cap. So I can go home today because these people on the Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication. And they force you to take medication and join S. Dunn Behavior Center. Coach Lewis know me. I was here. I had an aggravated robbery job. I shot a 9mm 2 times, one doorway. Camry,
Mr. Bonson, you can
German. They shot that 45.
go back with the bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial. Make
Sacrifice him, man.
that inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility. The lot.
Y'all should have been that.
All right, let's see. Mr. Eckhart, you've got Mark Marceau.
Do Judge.
3 cases. Good morning.
Morning, Judge. I think that needs to become a full case.
I'm gonna do it the right way. Very hard. Hey, can I go with my stuff, man? If they rather be murderers than rapists, don't keep their case, bro. But a brother, you know, fucking nigga call me. Right. Y'all gotta be a fucking rapist.
Good morning. Are you Mark Marceau? Are you Mark Marceau? This is cause numbers 26 DCCR 0396, 397, and 398. Mr. Marceau is charged in 2 of the cases with sexual assault of a child, and the third with continuous sexual abuse of a child. And what is the announcement?
Judge, Ms. French and I spoke last week about this case and about our plan. She's still in the process of obtaining CPS records. At some point in the near future, we're going to file a request with the court for a bond reduction. And those are the 2 kind of most urgent matters that we've got.
Okay. I don't see that request has been made yet for the CPS records.
Not yet. I've been preparing for trial that didn't occur yesterday.
Right.
I'll be preparing that motion in order, Your Honor, and also whenever the hearing is for the bond, if I can have a little bit of notice because of the family dynamics here, obviously the state will argue against that.
So what I'll do right now is just do a 60-day reset. Obviously, if you file a motion for bond reduction, we'll move that up immediately to a court date for that. And then we'll kind of push it back a little bit. The CPS records take some time to get. And then, so if you can get that, Ms. French, I'll get that signed this week. And that way we can get that process started. and then we'll see where we are, but we'll move it up for a bond reduction hearing.
Thank you, Judge.
All right, thank you. You can go back with the bailiff.
If you want to look at the video this week, it's
Let's see, Mr. Brian Lane,
Yes, ma'am.
you've got, Khalil Bradley Harris.
Yes, ma'am, that'll be a please.
I'll hold it till the paperwork's ready. And then what about Heyman Brandon?
If we may approach on him just for a second. Your Honor, the court allowed me some time.
Let's get Mr. Brandon out here. So he's, Heyman Brandon.
Hangman's right.
Yeah, just hold on a second, since he's here.
Okay.
Let him know what's going on. All right, you're Heyman Brandon. And this is 21-36605. Mr. Brandon is charged with murder, and what is the announcement?
Your Honor, we're respectfully requesting one more announcement. The court had reset it today for us to get an insanity evaluation from Dr. Capone. It took me a little while to get to Dr. Capone. I spoke with him yesterday. He said if I'll get him the materials, he could have an evaluation report done within 2 weeks. So if we could just have one more 30 days, I believe that's going to.
My concern is deterioration in our jail, because we finally have competency after years of not.
Right.
And so I need that done. This is, I'm going to reset it 3 weeks. We need to have it done within 3 weeks.
Well,
And so
I may be on vacation until the 15th. So.
do you have a vacation letter in?
Yes.
Okay, we'll take that into consideration.
Okay. Also, respectfully, if we get the report, I think the state's going to look at it. If the state wants to move forward, then we're going to ask for a bench trial. We want to set that in.
Well, let's see what the report says so that we know which direction we're headed once we get that report.
Oh,
So we'll just set it for an announcement, and then that day we'll know for sure what we're doing one way or the other.
Just-
Okay, sounds good. You can go back with the bailiff. Mr. Lewis? Mr. Parker, you've got Donald Cogdale's of sentencing. Donald Cogdale. Cogdale.
Go back for a minute. No, I heard it. Good. That case is a hard one for me.
Yeah,
Yeah, fine.
same, but
I agree with this.
Oh. Yeah.
You put it says on reset. It's a competency. Here.
Yeah.
I don't, I mean. it's-
Jonathan Richard, that's yours, Ms. Malfino, from what I show.
That's weird. Mine shows paying French.
Oh. Oh, well, I don't know whose it is.
That's weird. How are you? West Preston's. There you go.
All right, so are you Jonathan Richard? This is cause number 25, DCCR 0248. Mr. Richard was charged previously with evading arrest or detention with previous convictions and was found not competent to stand trial and sent to the John Dunn Behavioral Science Center for competency restoration. Received the report from them dated May 4th of 2026. I'm going to take judicial notice of the court's file. The report states that Mr. Richard has not achieved competency, is not competent to stand trial at this time. There is a trial competency evaluation report, which was prepared by Dr. Turner. And that report is that he is not competent and that current competency restoration treatment would be necessary for competency restoration. In addition to that, there is a forensic psychiatry report from a Dr. Shahani, again, with the finding that he is not competent to stand trial at the present time. Also, there is a physician certificate of medical examination for mental illness prepared by Dr. Shahani. It makes the finding that the patient is mentally ill, and a result of that, they state that he does not meet the criteria for inpatient, but meets the criteria for outpatient treatment because the nature of the mental illness is severe and persistent. As a result of it, if not treated, would deteriorate. In addition to that, there is a second physician certificate of medical examination for mental illness from Dr. Select. That has the same finding that Mr. Richard is still not competent to stand trial and that outpatient treatment would be warranted for competency restoration. Any other evidence with regard to competency?
None from the defense judge.
So obviously, we all know, and for the record, we do not have an outpatient competency restoration program here in Jefferson County, nor in jail competency restoration. And so I don't have any choice but to order inpatient treatment because we don't have that, unfortunately, here. So at this time, I am going to find, based on those reports, that Mr. Richard is still not competent to stand trial, that inpatient competency restoration placement is necessary because that is what we have in order. Mr. Richard, for a period of not to exceed 1 year to the appropriate facility for competency restoration. We obviously need to make sure, Ms. Malfino and Mr. Parker, that y'all take a look at the dates on this and how long he has already been in custody. Since it's a state jail felony, we're probably
Should expire while he's in.
so we need to check those dates. If you'll get that date, if you'll make a note so that we know we can get him back whenever that date hits.
Okay, I'll email.
All right. All right. You can go back with the bailiff.
You can judge.
Mr. Rojas, you've got Manuel Cardenas.
No, it was 12.
Okay. We're gonna reset Sarah Jordan.
Jordan?
Mm-hmm.
And also, Judge, we're gonna ask to reset Mr. Pugh. Willie Pugh.
Okay. What's up with that one?
Ashley was gonna.
I just haven't been able to reach the officer yet, Judge, sorry, just 1 week would be.
Yeah, we can be fine.
To ratify off of.
Good morning, sir. Are you Manuel Cardenas Jr.?
Yes.
This is 26 DCCR 0040. And Mr. Cardenas is charged with injury to a child, elderly, or disabled individual. And I'm going to take, okay, let me take judicial notice of the court's file. Mr. Cardenas was evaluated for competency to stand trial. And Dr. Grimsley prepared a report and evaluated him. I received that report. It's dated April 8th of 2026 with the finding that Mr. Cardenas is competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
There.
All right, and will he waive the formal reading of the indictment?
He will, Your Honor.
All right, Mr. Cardenas, in cause number 26 DCCR 0040, you're charged with the third-degree felony offense of injury to an elderly individual from October 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would also include having no contact or communication with Manuel Cardenas Sr. Do you understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cardenas is not competent?
No, Your Honor.
All right, Mr. Cardenas, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case so that we can make sure everything is covered that needs to be while you're on probation. And then we'll come back later for sentencing. And it looks like the state's you're opposed to a bond.
I am, Judge, just due to the nature of the case and the underlying need for that competency evaluation. I have not had an opportunity or have not heard back from Mr. Cardenas Sr. And I would just prefer with that PSI to make sure if there's any APS orders, et cetera, in place, that we have a pretty strict no contact structure. Obviously, that's his father.
Sure.
So it's.
All right, we'll see you back at sentencing. You can go back with the bailiff. Kelvin Johnson, Mr. Rojas, it's a sentencing.
Kelvin Johnson.
Good morning. Are you Kelvin Johnson?
Yes, ma'am.
And this is 25 DCCR 1781. Mr. Johnson was previously in court, entered a plea of guilty to the state jail felony offense of theft of property with previous convictions, entered pleas of true to prior convictions, making this a third-degree felony, enhanced. The agreement was for a cap of 5 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
Not from the defense.
Not from state.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI, what stands out is criminal history. It looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors anyway are trespassing cases. And I would guess, and Mr. Johnson tells me this is the case, that most of those, because he was homeless, didn't have any place to go. And as the court knows, if you're homeless and don't have any place to live, you're going to probably pick up some trespassing cases. He does have 2 prior cases where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out that I think the most or the felony probation case was in 2000, and the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed between those two. As far as this current case is concerned, if you look at his statements, he looks like he was stealing food and clothes, necessities. $72 worth, which would ordinarily be a misdemeanor, but for the fact that he already has his 2 prior theft cases, and the other felony case would bump up to a 3rd degree. He's asking for probation, Judge. And again, the felony history anyway is from the last felony case is from 2003. It looks like 23 years ago. He tells me that prior to being arrested, he was working for a church, getting paid on a daily basis. I also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership came and picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to PSI, he's going to be living with his mom. So we're asking the court to consider probation, a deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing necessities and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malfino?
Judge, I don't think he's necessarily not a candidate for probation. I think it should include safety. In my opinion, the PSI reads as if he expressed interest in that. I would like to ask him if he really wants to take advantage of that. Otherwise, we're just going to be back here in a year on the same situation.
And I apologize. Mr. Johnson did want to speak to you, so whenever.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it where she took my kids to Louisiana. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. You know, one thing about me, I live and learn. But 2 things happened as I was doing what I was doing. I stole out the store and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, you didn't have to do this. They would have gave you the food. And then showed me instead of stealing, I could just ask. And then another time I was panhandling on College Street at the burrito place. And across the street was a car wash. And instead of me, and I looked and I thought about something. And I crossed the street and I started asking them to wash their cars. So what I'm getting at that is, it's better to work than to be doing all that. You know, it's a different way that I'm going to go by doing things this time, you know.
How old are you?
45.
Yeah, time to start doing things
Yes,
different, huh?
ma'am. Yes, ma'am.
Anything else?
No, Judge.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably going to be, the worst I could do today is give you 5 years in prison. If I sent you to prison,
Wow.
you'd be out in 2 or 3 years and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time.
Yes, ma'am.
It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
For probation.
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find those prior convictions that you pled true to, true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the SafeP program. So you'll go to the inpatient part of SafeP in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to.
Right.
If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law.
Today's courtroom session showed how quickly a case can change, from bond revocations and drug testing to plea agreements and probation warnings. Judge Raquel West made one thing clear: respect the court, follow the rules, and take every condition seriously, because one mistake can completely change the outcome of a case.